My name is Teresa Rusnick. For those of you that don't know me, I'm a labor and employment attorney here at Bond. I work out of the Rochester office, although I am in Syracuse pretty frequently. Welcome to Gender Identity and Expression Harassment Prevention for CLE credits this morning. Just a couple of housekeeping things. Bathrooms are down the hall if anyone should need them. There is food and coffee in the back. Please help yourselves. At the end, I'll try to remind you to fill out the evaluation sheets. And then please make sure that you've signed in, and that goes for everyone in the respective offices as well. Please make sure you've signed in so that we can send you your certificate. So this is what we're up to today. This is our overview for the presentation. We're going to start by going over a glossary of terms, just so everybody knows what the different terms mean when we go throughout the presentation, and we're all on the same page there. We're then going to move on to federal laws on gender identity, specifically gender identity, harassment, and discrimination. We'll do the same thing for New York State laws on gender identity. It should come as no surprise to anyone familiar with New York State that there are substantially more New York State rules on gender identity, harassment, and discrimination than there are at the federal level. We'll then talk about gender-based stereotypes and how those can be a form of harassment, particularly sexual harassment. We'll talk about restrooms, pronoun usage, religious objections, gender identity and disabilities, adopting a non-discrimination policy specifically for gender identity discrimination. And throughout this entire presentation, I'm going to try to give as many practical tips as possible. So, thoughts to guide our discussion. I know on this topic, perhaps more so than some others, people have different viewpoints and perspectives. It's my hope, and when I've given this presentation, I've never had a problem with it, that everyone is respectful and asks questions respectfully and just really remembers that people come from different places and have unique life experiences that shape their beliefs. But please, feel free to ask questions for anyone in the other offices. If you unmute yourselves, particularly at the end, I'll be able to hear your questions. So we're going to start off with a glossary of terms. These are just some basic terms that everyone should be aware of because I'm going to be using them throughout the presentation. If anyone's wondering where I got these terms from, and I know people do have different definitions, I took a class at the Out Alliance of Rochester a couple of years ago, and they very generously allowed me to use their glossary. So that's where these terms came from. So just please take a minute and review them. I don't think these should be new to many people. I'll just highlight some of the ones that might not be as familiar. So someone who's bisexual is someone who's sexually and romantically attracted to men or women. Someone who's transgender is someone whose gender identity doesn't correspond to the gender they were assigned at birth. Someone who's questioning is someone who's unsure about their orientation or identity. And then the plus is the inclusion of all gender identities and expressions, which we're going to be talking about today. And then these are another couple of terms. So when we say sexual orientation, we mean the part of a person's identity related to whom they're sexually attracted. Cisgender is someone who identifies with their birth gender. And then a non-binary or gender non-conforming person is someone who doesn't identify as a member of either gender. They might identify as both, neither, or non-gendered at different points in their life. So are we all clear on those terms? These are some of the disfavored terms. Some of you might have heard these maybe some years ago. Maybe you're still hearing them. These are terms that have fallen out of favor with the LGBTQ community. So I just want everyone to be aware when you go back to your own offices and your own law practice, these aren't necessarily considered appropriate terms anymore. So things like transvestite and transsexual, you're going to hear a little bit later that those terms are actually used in the Americans with Disabilities Act, which shows you how far we've come since that law was passed. Those are disfavored terms. So is lifestyle choice or alternative lifestyle. I think as a society, we've come to realize that sexual orientation is not a choice. It's just who you are. Sexual preference. Preferred pronouns, I think, is probably surprising. I see this one a lot, so I'm going to highlight it. We always see this is their preferred pronoun, this is not her preferred pronoun. I think sometimes you can still use that, but what I've been hearing is that it's correct or incorrect pronouns are the right terms to use for that. Particularly, you'll see the pronoun issue come up if you're in colleges or schools or places of higher education. Sometimes you see it on people's signature blocks. They put their correct pronouns underneath it. I've even seen it on some business cards recently. So that's what's going on if you see that under somebody's name. And then hermaphrodite is another term that we don't use. But pretty generally, and this is a good rule for dealing with this subject, use the terms people use for themselves. there's some amount of reclamation in the community where they're taking back terms that have been used to prejudice or discriminate against them before. So if people ask to be called or use one of these terms for themselves, obviously it's all right to do that. So practical tip number 1, when referring to trans people at a time in their lives before they transitioned, use their current pronouns and names. So this is a good example. Caitlyn Jenner went to the Olympics. We wouldn't say Bruce Jenner went to the Olympics. And I am comfortable using this example because Caitlyn Jenner is one of the most famous trans people to ever exist. So I know I'm not accidentally outing Caitlyn as a transgender woman. The reason you want to use people's correct names and current names and pronouns is because you never know who in the room might be aware that they're trans, who in the room might be aware of their former name or their dead name. So you always want to use their current name and pronoun, even talking about a time before they transitioned or perhaps before they officially changed their name. Don't ask for a person's former name pre-transition. It's considered rude, and frankly, it's irrelevant for all of your purposes. You always want to use the name that people ask you to use. And then please politely apologize if mistakes are made. Most trans people and non-binary people that I've ever met give you a lot of chances to get the pronouns and names right and are very willing to overlook a couple of mistakes, especially in the beginning. So this is the genderbread person. This is one of my favorite graphics because I think it explains very well the differences between gender identity, gender expression, biological sex, and sexual orientation. This isn't a new graphic. It's been around for a little bit, but I think it does a very good job at explaining the differences between terms that some people can sometimes get confused. So gender expression is how you express your gender, what you wear, how you talk, what you sound like. Gender identity is what you identify as, what you think in your mind that you are. Your sex is your biological attributes that you're born with or otherwise. And then orientation is who you love and who you have relationships with in a romantic way. So those are our different terms, and I think that graphic just illustrates it very nicely. So with that, that's my little introduction to this topic. We're now going to jump into the legal portion of it, and we're going to start off with federal law on gender identity. As some of you might guess, it's going to be rather short. There are currently no federal laws offering explicit employment protection for non-binary or transgender people working in the private sector. There is an Executive Order 13672 from 2014, which made gender identity a protected category for federal employment. That has not been revoked by the Trump administration, although it was weakened by the passage of another executive order saying that contractors don't necessarily have to follow the labor and employment restrictions in executive orders. So it's been somewhat weakened, although not formally revoked. Some other federal laws, such as the Americans with Disabilities Act and the Family Medical Leave Act, may be available for medical conditions related to gender identity. We're going to be talking about that in a couple of minutes. There's gender dysphoria, which is somewhat of a controversial term now, and I'll go into that more when I get to this point, but it is still a medical condition, and sometimes when people are diagnosed with that, there's courts that have said they can get protection under the ADA or the FMLA. Title VII is our most famous employment law on the federal side for protections in the workplace. Various courts around the country have held that Title VII protects transgender people, or at least could potentially protect them. So Title VII is the law that prohibits discrimination in employment on the basis of race, sex, national origin, sexual orientation, and several other protected categories. Courts have found that protections and have held that transgender identity is identity that is related to sex and is therefore protected under Title VII. So the courts have kind of done a workaround here. So they haven't been able to say explicitly transgender people are protected under Title VII because they're their own protected category, but they've done a loop around and said, well, transgender identity and gender identity more broadly has to be connected to sex, which is protected, and so we're going to go ahead and say that Title VII protects transgender people as well. So the 6th and 11th circuits have held that Title VII does protect gender identity or trans people using that hook, that loop around that I just mentioned. However, the 5th Circuit ruled the opposite way in February of 2019. The 2nd Circuit has not yet ruled on this issue. However, if you look at a bunch of the lower courts, especially in the Southern District, they have found that people who are trans or have different gender identities are protected under Title VII. So I think it's a safe bet to see where the Second Circuit would go if it ever was risen up to that level. The EEOC, of course, recognizes transgender status and gender identity as protected categories under Title VII. They have any number of pages of guidance on that on their website. I encourage you all to check it out. It's very useful for different terms, and it's helpful to just get a better understanding in this area. The EEOC, I can just tell you colloquially, has been very interested in bringing cases in this area, just finding, and you know how the EEOC is always looking for the new frontier of employment litigation, so they've been very active about bringing cases in this area. Particularly the EEOC at the moment, and we'll talk about this case in a minute, has brought a case up to the Supreme Court on whether or not trans people are protected under Title VII. So that case I'll go over in a few minutes, but just a coming attraction and knowledge of where the EEOC's position on this really is. But for now, we're going to turn to state laws on gender identity. We all live in New York State or practice in New York State in some capacity, so we need to be aware of the laws. The New York State Human Rights Law is our main law that prohibits workplace discrimination on the basis of all of these protected categories. So it makes it illegal to discriminate on the basis of age, race, color, sex, sexual orientation, gender identity or expression, national origin, marital status, disability, military status, domestic violence victim status, criminal or arrest record, predisposing genetic characteristics, or known association with any of these. And I swear to you, that list gets longer every time I say it. For those of you that practice in employment law in New York, you know what I'm talking about there. Gender identity or expression for purposes of this presentation is obviously the one I want to highlight. That was added to the New York State Human Rights Law several months ago. We're going to talk about that in a minute. And obviously retaliation against an individual for filing a complaint, opposing an unlawful practice, or testifying or assisting in an investigation or proceeding for when someone has made a complaint on any of the bases of these protected categories is also illegal under the human rights law. So keep in mind with that as well when we're talking about transgender and gender identity harassment and discrimination. Oftentimes what we see is not that the underlying sexual harassment is what gets employers in trouble. It's the retaliatory actions that come after the person files a complaint. So just something to be aware of. So the human rights law, GENDA, amended it back on January 25th of 2019. That was effective immediately. It amends the human rights law by adding gender identity or expression as a protected category. Everyone should make sure that their own organizations and that their clients' organizations have policies and equal employment opportunities and sexual harassment policies that are updated accordingly to add this new protected category. So GENDA, the legislation, defines gender identity or expression as follows. A person's actual or perceived gender-related identity, appearance, behavior, expression, or other gender-related characteristic, regardless of the sex assigned to that person at birth, including but not limited to the status of being transgender. So that's New York State's definition of gender identity or expression. That's now what's considered protected under the New York State Human Rights Law for employment purposes. So this protects the way a person expresses gender through speech, dress, or behavior. So with that, it's a nice segue into gender-based stereotypes, because gender-based stereotypes can lead into types of harassment and discrimination if they're not dealt with properly. So just beginning with what a gender stereotype is on its face. Gender stereotyping is a type of sexual harassment. It occurs when personality traits are considered inappropriate because they don't conform to other people's ideas or perceptions about how individuals of either gender should look or act. So that extends to things like speech, personality, lifestyle. We most commonly see it when someone's performing a job that was performed in the past by someone of the opposite sex or gender. So that's things like men can't be nurses, or women can't work with technology, or men don't dress that way, or women don't wear their hair like that. All those are examples of what's called gender stereotyping, and that is something in the latest round of sexual harassment legislation and guidance New York State has said needs to be included in those trainings as a type of sexual harassment. Of course, we also have transgender stereotypes. Similar to gender stereotyping, there's different things that people think trans people need to do to be protected under the law These are some stereotypes that I want to dispel right now. So to be protected under the human rights law, trans people do not have to officially change their legal names. They can, but they do not have to. They don't have to ask to be called by a different name. Again, they can, but do not have to. They don't have to have surgery or take medications, including or possibly excluding hormones. Again, I think we see in the common lexicon that some trans people do that, but certainly they don't all have to, and they don't have to get protection under the human rights law. They also don't have to dress in a certain way or use a particular pronoun. They don't have to produce medical records to the employer as proof of transition. I see people get tripped up on this one a lot. Someone says, I'm trans in the workplace, and the employer says, okay, fine, I want to see your medical paperwork. That's not appropriate unless the person has been diagnosed with gender dysphoria and they're asking for some type of accommodation or leave. But it's not appropriate to just, if someone discloses to you that they're trans, to say, oh, I want to see your medical records. That would be considered a type of discrimination or harassing behavior. So, gender identity stereotypes for non-binary and gender non-conforming people. These are the people that you'll often see going by third-party pronouns, such as they, them, theirs, or ze, them, their, are two of the more common third-party pronouns. But these are some of the gender stereotypes that often are attributed to that group. So they're not trying to make up their minds. That's not something appropriate that we say to non-binary people or gender non-conforming people. They don't have to use any specific pronoun. There are any number of third-party pronouns out there. There's at least a dozen. I've heard different estimates that there may be many dozens of third-party pronouns. I've highlighted the two most common that I've seen, they and them and ze and them. But there's also her and zer and different other third-party pronouns. So use the pronouns that people use for themselves or that they ask you to use for them, and you won't go wrong. Non-binary people don't have to dress in a stereotypically male or female way, although they may choose to do so. Some may dress in a stereotypically male or female way on one day, and then in a stereotypically male or female way in a different way the next day. They don't have to have their names legally changed. Similar to transgender people, they don't have to produce medical records to prove that they are non-binary. So we all clear on that? Gender stereotypes, transgender, gender identity stereotypes? Okay. So that leads me into pronoun usage, which is where I see a lot of people get tripped up. And I'm going to just tell people in the room that this is a very serious issue, not calling people by their correct pronouns. For those of you in New York City, I know that you're mostly aware that we've seen some very high penalties imposed by the New York City Commission on this area of not using people's correct pronouns. I've had several employment discrimination cases based off of this issue alone for trans and non-binary people, so it's definitely something the local Division of Human Rights is very attuned to. It's not something they're willing to dismiss or ignore. I've had several cases get probable cause determinations solely because incorrect pronouns were being used. That was enough for the Division of Human Rights to say there was conduct that was rising, or at least probably rising, to the level of sexual harassment. So it's definitely something that we saw start in New York City, these transgender and pronoun cases particularly, maybe about 5 or 6 years ago, and then, which should come as a surprise to no one familiar with the New York City human rights law, those changes tend to just sort of drift upstate. So now we're seeing those changes come upstate in a big way. And I've seen that in my own case law practice. If you see someone like my boss, Jim Houlihan, he worked as a lawyer for 35 years before he ever saw a transgender discrimination case. And I've been practicing for considerably less time than that, and I've already seen several of them. So it's definitely something that is coming to New York State, it's coming to your businesses, to your law firms, and it's something we absolutely need to be aware of. So with that, pronoun use. Failure to use correct pronouns for individuals in the workplace is a type of discrimination. We've talked about correct pronouns, which may include they, them, he, him, she, her, ze, them. The New York City human rights law makes it explicitly illegal to use incorrect pronouns. It's likely illegal under the New York State human rights law as well. I can tell you from my own private practice, the New York State human rights is taking the position that it is illegal. The division has taken that position even if it hasn't been explicitly spelled out anywhere. When you're talking about pronoun usage, please remember the platinum rule. Treat other people the way they want to be treated. Use the pronouns that they use for themselves or that they ask to be used for them. So here's an illustration, our first one. I do have a couple of these sprinkled in here. Zoe has supervised the same group of people for 10 years. A few years ago, one of her team members, Adam, transitioned from female to male. Zoe calls Adam by the female pronoun repeatedly, and Adam corrects her each time. 3 months after Adam's transition, Zoe is still using the incorrect pronoun. Is that illegal? Yes, right? You do get, I think, a couple of good faith chances to get the pronoun usage correct. I know many trans people will give you many, many, many chances, especially if you knew them before their transition by a different name and different pronoun. But if it's been months and months and the incorrect pronoun is still being used, that starts to look like something that's not an accident. It starts to look like something intentional, and it certainly could rise to the level of discrimination.
That's a question.
Yeah, of course.
So I'm not terribly familiar with this great so far. If that person had said, I prefer to be referred to as Z, and people are calling Adam him, is that wrong?
Yes, that's an excellent question. So yes, so sometimes the person's name won't necessarily quote unquote match the pronouns that they're asking you to use for themselves. That can be due to a number of things. Some people make the transition in process in different steps. Some people may not have officially changed their name yet. Maybe they haven't officially changed their gender marker on some of their documents. It can be somewhat of a fluctuating process. I do name changes for transgender people pro bono, so I can tell you just how long this process can take sometimes to get all the documentation in line. So it could be because of that. It could be because they want to be called Adam, but don't necessarily identify fully as a man. So yeah, that's when people say, so if I said to you, I'm Teresa, and I use the pronouns ze, them, there, I would expect you all to respect that and to make sure that you weren't using the incorrect pronouns, because it would start to look like harassment or discrimination to me after a certain period of time. Are we all clear on that? That was a really good question. Anyone else have questions? Wow. You better have questions at the end, because I present this to HR people all the time and they can't stop themselves with the questions. Of course, they're on the front lines for a lot of this in a way that some of us aren't. So, is Zoe's conduct illegal under the New York State human rights law? Yes. Gender identity, including transgender status, is protected. Correct pronouns must be used. Is it illegal under the New York City human rights law? Yes, in a very big way for my New York City listeners and for those of you that interact with the city law. So the Commission has explicitly stated that incorrect pronoun usage is discrimination. Violators are subject to civil penalties of $125,000 for negligent violations and up to $250,000 for willful violations. Yes, sir.
I know you said that mistakes can be made in terms of pronoun usage, but as the law is written, if you just use the wrong pronoun once, would that be interpreted as a violation?
I think it could be. I think it's difficult to know for sure because it's not necessarily, I would say, per se discrimination to use the incorrect pronoun once. The cases I've seen that have gotten probable cause by the Division of Human Rights, it was used multiple times incorrectly, because remember, when we're talking about harassment and discrimination, it still has to meet, or at least previously, it still had to meet that severe and pervasive standard to be harassment or discrimination. And so I think using the incorrect pronoun once wouldn't have met that severe and pervasive level. Now, of course, for those of you that know, and for those of you that don't, let me enlighten you right now. New York State has changed the sexual harassment definition, and that would apply to this as well, because it applies to all types of discrimination and harassment. They have changed it from severe or pervasive, although it remains there under federal law, to anything that's not a petty slight or a minor inconvenience. So it is your and I's best guess whether using the incorrect pronoun once would be a petty slight or a minor inconvenience. Some of our New York City counterparts may be able to tell us that better because they've been operating under that standard for longer than we have. But for all of us in upstate and other parts of New York, your guess is as good as mine at this point, whether the incorrect usage once would be considered a petty slight or more than a minor inconvenience. I simply don't know. We'll see. As I always tell my HR people, I'd love to be the lawyer that tests that case, but you would probably hate it. So anyway, New York City is imposing very large penalties in this area. Like I said, $125,000 if you do it negligently, so over and over and over. $250,000 for willful violations if you write in an email. I am not using the correct pronouns because I think it's ridiculous and I don't want to, and I'm instructing all my supervisors not to do that. That is a willful violation, and that can get you very high penalties. So, restrooms and gender identity. You guys have all been good because no one has asked me the bathroom question yet. Maybe because I told you it was upcoming in our glossary and our overview earlier. But restrooms and gender identity is one of the questions I get the most from lawyers, from non-lawyers, from HR people, from regular people who hear that I lecture about this topic. What do you do about the bathroom? So let's get into it. Various state laws, I think North Carolina being the most famous in this area, back in 2016 mandated that individuals use restrooms consistent with their biological attributes. That was, of course, famously repealed in 2017. However, if you look at Kentucky and Tennessee, their state legislatures are currently considering bills similar to the one that North Carolina repealed. So this is certainly something that states still have very much on their legislative minds. It's certainly something important to consider when we're talking about this topic. Where you are matters a lot on what your rights are. So there's no evidence, just colloquially speaking, and this I think is something is good to clear up at the outset. There is no evidence that gender segregated restrooms are safer for cisgender women than unisex restrooms or integrated bathrooms. There's just no evidence. To the contrary, 70% of respondents who were transgender in a UCLA survey in 2013 said they were denied access, harassed, or assaulted in public restrooms. So I really want to dispel that myth. I read a lot of literature on this and a lot of statistical surveys. It is not cisgender women who get harassed in bathrooms. It is transgender people that get harassed in bathrooms. And just the statistics have borne that out time and time and time again. So I want to make sure that everyone, when you go back to your workplaces, when you're advising your clients, if you get questions about this, and you will, because people are very concerned about this. They think they're trying to keep women safe, and that's a very noble goal. It's just not necessarily an accurate one when we're talking about this. So if anyone wants the statistics or any of the studies I've looked at, I think several of them are included in your materials packet, but if you ever want more, I can certainly provide those to you. New York State has not specifically passed any cases or laws on bathroom access for people based on gender identity. There have been some passed in the school district context for kids in public schools, but when we're talking about private sector, we're really back with gender and the New York State Human Rights Law. Most likely, employers must allow individuals to use the restroom that conforms with their gender identity. To fail to do so, I think, is a substantial legal risk. Again, I'm happy to be the person that brings that case and tests it out, but I'm pretty sure I know how it would go. Everything is trending in that direction, which is allowing people to use the restroom of the gender that they identify with. New York City has been less shy in this arena, and their Commission on Human Rights has explicitly stated that failure to allow individuals to use the restroom consistent with their gender identity is a violation of that law. The Division of Human Rights will more than likely take the same position regarding restrooms. As I said, national and local laws all trend in this direction. If we look at the state typically following what New York City does, I think it's only a matter of time before they follow them on restrooms the way they did on pronoun usage and other areas in this arena. So the practical effect, if any of you are advising your clients or you're going back to your own law firms and this issue comes up, please err on the side of letting employees use the restroom of their choice, including whether or not those restrooms are gender segregated for everyone, if you know what I mean. Like it's It's, I have to repeat questions. Sorry, guys. If I forget that, please tell me because they could not hear your previous two questions. So yeah, sometimes people will say, okay, I solved this problem. I created a single stall unisex bathroom for this transgender person to use. That's their bathroom. They can't use the group bathroom. That, I think, by itself would be discrimination as well. You have to let them use the group restroom of the gender they identify with. New York City has released some guidance on that particular topic. Interestingly, OSHA jumped into this arena several years ago, and this really surprised me because we don't often see federal agencies being ahead of New York State, but OSHA's been on this train since 2015. So they have guidance for restroom access for transgender workers. It was issued in an advisory recommendation. It's not binding, it's not official guidance, but I think it's incredibly interesting just because of who published it and when they published it and what it says. So it explicitly favors allowing individuals to use the restroom that conforms with their gender identity. It's several pages of really interesting guidance and interesting materials. It's available at OSHA's website. But these are some of the quotes that really jumped out at me. Restricting employees to using only restrooms that are not consistent with their gender identity or segregating them from other workers by requiring them to use gender neutral or other specific restrooms singles those employees out and may make them fear for their physical safety. Bathroom restrictions can result in employees avoiding using restrooms entirely while at work, which can lead to serious physical injury or illness. Under OSHA's sanitation standards, section 1910-141, employers are required to provide their employees with access to toilet facilities. OSHA took this standard and interpreted section 1910-141 to require employers to allow employees prompt access to sanitary facilities. Further, employers may not impose unreasonable restrictions on employee use of toilet facilities. So if you look at what OSHA did here, they said we have an existing sanitation standard that we've interpreted in this way. And when we're looking at the transgender bathroom access, we may very well, if this issue came to us, interpret it to say if you don't let a trans person have access to the bathroom of the gender they identify with, you're in violation of our sanitation standard because you may be causing them physical injury or illness by not allowing them access to the restroom. So I include this because I think it's incredibly interesting. I would not have expected OSHA to be the federal agency in this arena, but they're here and they've actually been ahead of New York State on this issue, which is something we do not usually see. So that's another thing you can point to if you're advising clients or if you're going back to your own law firm and saying, why is this important? Why do we have to do that? You can say, well, listen, OSHA's jumped into this and they've said it's a safety issue. So I think that's something very interesting. These are some practical tips when you're dealing with the bathroom issue for your clients or at your law firms. Create a single-use restroom that anyone, regardless of gender identity, can use. A lot of times, a good way to respond to women or men's complaints that they feel unsafe in a restroom with someone who is trans or gender non-conforming is to say, okay, well, you know, we are going to let this person use the group restroom of the identity that they have. But if you're uncomfortable, feel free to use this single stall bathroom right over here. Go ahead, and that kind of solves the problem right then and there. So it's opening up that single-use restroom not just to the trans person or the non-binary person, but to everyone in the workplace for their own use. Educate employees regarding transgender rights and bathrooms. Sometimes if you have employees who are being resistant or stubborn or still have fears about this, it's good to just educate them, mentioning those statistics that I referenced earlier, or also just saying this is what the law says and this is what we need to do to comply with the law. And then sometimes people might not still like it, but they'll understand it's something that has to be done. So to require a transgender individual to use a single-use restroom and not allow use of the group restroom is discrimination under the New York City law. Very likely it's going to be discrimination under the New York State law as well. So this is our illustration for restrooms. Sandra was hired by XYZ company 2 months ago and has been using the women's restroom ever since. Recently, one of Sandra's coworkers learned from a mutual friend that Sandra is a transgender woman. This coworker refused to use the women's bathroom with Sandra anymore and told HR that she feels unsafe doing so. She demands that the company stop Sandra from using the women's restroom, saying it is giving her stress and anxiety at work to share with Sandra. So what should the company do? I don't expect any of you to answer this. I'll tell you the answer. So Sandra is our transgender woman, so we know that Sandra has to be allowed to use the bathroom of the gender that she identifies with. So we need to allow Sandra to keep using the group women's bathroom. About our coworker who's refusing to use the women's bathroom with Sandra anymore and says she's feeling unsafe, it's a good idea to start educating her about this statistic, saying that there's no proof that cisgender women are unsafe in group bathrooms that are shared with trans people or non-binary people, and that it's actually the opposite way around. To the extent she claims that it's giving her stress and anxiety at work, for my labor employment attorneys in the room, you're now thinking disability, disability, disability. What do we have to do if she's claiming disability? Well, stress and anxiety at work, fine. But if it's related to this, no dice, right? You can't give someone a reasonable accommodation that breaks the law in another respect, right? It's never a reasonable accommodation to break the law. So maybe she is experiencing stress and anxiety. Maybe she is going to somehow get you a doctor's note that says, I'm experiencing stress and anxiety because I'm being forced to use a bathroom with a transgender person. Even if you could get a doctor to write such a note, which I'm hopefully doubtful would ever happen, I think the company is within its rights to say, listen, we can't give you this as an accommodation because that would be breaking the law, and we're not going to do that. As a type of accommodation, they could say to the coworker, we have a private bathroom, please feel free to use that to dispel any stress or anxiety that you might have. So these are tricky issues, right? When you have multiple competing protected categories, you have potential disability and you have a trans person here, both of whom are protected. But I think thinking outside the box and really thinking it through can help with some of these problems. So, yes, go ahead.
I have a question regarding leased facilities. So if you're a tenant in your leased building, there's only a women's restroom, a group restroom, and a men's restroom. Responsibility with respect to the landlord, the tenant, like who would be responsible for accommodating maybe new unisex bathroom or whatever type of bathroom you might need then to accommodate your employees that are in their leased facility.
Okay, so the question is, if you're only a tenant in a leased building or in a leased space, who would be responsible for making the restrooms able to be accessed by everyone of every gender identity or orientation? Would it be the landlord or would it be the tenant in this case? So that's an interesting question. So I have seen some employers, let me just back up. I've seen some employers who have been having trans people in the workplace create unisex bathrooms or one did not previously exist. I do not think that's something that has to be done. I don't think that that's a type of accommodation that needs to be made. I don't think if there isn't already a private bathroom in the facility that the landlord or the tenant would be under any obligation to create one. I do think the tenant, as well as the landlord, would want, or whoever the entity is that's in the space, would want to make sure that a trans person can use the group restroom of the gender they identify with. So I think that's how that would be handled. Does that answer your question? Okay. Because sometimes I do get people saying, oh my God, they're walking out of here going, I got to modify my facilities. I got to call a contractor right now. We don't have a private bathroom. What are we going to do? And while I've certainly seen some employers take that tack, I don't think there's anything in the law or the case law or the guidance suggesting that that's something employers have to do, because realistically, all the law is saying is just let the trans person or the non-binary person use the group bathroom. So there really would be no reason to create a separate bathroom just for those people or just because you have someone like that in your workplace. So bathrooms are my first sticky issue that people get tripped up on. The second one is religion and gender identity. So I'm just going to dive into it. So we know the human rights law and other laws, Title VII, prevent discrimination against employees and other people on the basis of religion. Religion is one of our protected categories. Some people may claim that they don't want to work with transgender or non-binary individuals or won't use the correct pronouns or share a restroom for religious reasons. They'll say, my religion won't let me use that pronoun, or my religion doesn't want me to call the person by anything other than the name they were given at birth or whatever it is. I'm just making things up. Some religions do have those beliefs, and those are legitimate beliefs for those religions. I understand that. I respect religious beliefs. However, much like our disability situation, religious beliefs aren't an acceptable reason for discrimination, right? So while you do have a freedom of religion in this country, while you are protected for your religious beliefs at work, what that means is your employer isn't going to fire you because you belong to a religion with this belief. But they're also not going to let you break the law in their workplace just because you belong to a certain religion. That's simply not going to happen. And sometimes for people who get a little tripped up on this, it's easier to take it and switch it to another protected category, right? So this would be like saying, my religious beliefs won't allow me to share a workspace with someone of a certain age or a certain race or someone who's disabled. None of you would allow that in your workplaces. None of you would advise your clients to let that happen in your workplace. It's the same thing here. Gender identity and expression is now just as protected as race, as age, as disability status. It all belongs in the same category. And the same is true for the bathroom example I was talking about. It's like someone saying, I'm not going to use the restroom with this person because of their age, or because of their disability status, or because of their race. None of you would allow that in your workplaces. Or if you would, come talk to me because we should be friends. None of you would allow that in your workplaces. And so sometimes it's easier, people can get tripped up on the terminology here, to just take it in that context and think, oh yeah, I know what the right thing to do here is, right? Like you would never, if someone gave you a doctor's note saying, I can't work with someone because of their race and it's giving me anxiety. You throw that in the garbage, right? It's the same thing here. So, to refuse to use correct pronouns, work with, or use the restroom of a non-binary or trans person is legally the same level of discrimination as refusing to do any of those things with anyone else because of their membership in a protected category. As an example, I refuse to use the bathroom with Susan because she is a transgender woman is the same, legally speaking, as I refuse to use the bathroom with Susan because of her race. You would never allow the second, don't allow the first. So that brings us to that Supreme Court case that I mentioned earlier, EEOC versus R.G. Harris. In 2018, the Sixth Circuit held that religious objections do not justify noncompliance with Title VII when it comes to transgender individuals. So let me just give you a little bit of background on the R.G. Harris case. R.G. Harris was a funeral home operating, I think, in Michigan, and they had an employee that transitioned their gender. And when that happened to that employee, she was fired from the funeral home. The funeral home went to the lower court, the lower federal court, and said a couple of things in their own defense. One, we have a religious right to fire this person because she's trans. Two, there is no protection under Title VII, so there's nothing you can make us do. And three, our customers aren't going to come and patronize our business if they know we have a trans person working for us. So those are the three things that the funeral home said as a defense for their actions. The lower court said there's nothing we can do because it isn't protected under Title VII. Transgender identity isn't protected under Title VII. The individual, through the EEOC, appealed that case to the Sixth Circuit, which said that religious objections don't justify noncompliance with Title VII, and to require the business owner to comply with Title VII's prescriptions on discrimination does not substantially burden his religious practice, nor do presumed or actual customer biases against transgender people justify discrimination under Title VII, and transgender identity is protected under Title VII because of its connection to sex, which is what we were talking about earlier. So the Sixth Circuit gave the EEOC a big win. That case has been appealed to the Supreme Court. They're going to be hearing it this term. So we should get some definitive guidance by next year at this time as to whether trans people are protected under Title VII. So that's just something to watch out for and be aware of. The Supreme Court will be hearing this case, and hopefully they give us some good case law one way or the other on this issue. So, religious objections illustration. Adam has been an employee at XYZ company for 10 years, and he is devoutly religious. He has recently learned that one of his coworkers, Eve, identifies as a non-binary individual. Yesterday, Eve said to Adam, the pronouns that should be used for me are ze, them, or zer. Adam refuses to use Eve's correct pronouns, and when the HR director tells him he has to, he threatens to sue the company for religious discrimination. What does XYZ company do? I'll tell you what they do. They say, bring it on, Adam. You have to use the correct pronouns for Eve. It's illegal not to, right? And I'd rather, as an employment lawyer, defend the company from Adam's religious discrimination lawsuit than defend the company from the inevitable gender identity discrimination lawsuit that Eve's going to bring if Eve is not called by Eve's correct pronouns, right? So that's, I mean, if it's going to be one lawsuit or the other, I'd pick the religious discrimination one, because at least we can point to the human rights law and say, hey, we're not firing Adam because he belongs to a religion that doesn't believe in trans people. We're firing Adam because he consistently insisted on breaking the law in the workplace and wouldn't use Eve's correct pronouns. So, I mean, you're going to get sued in either way in this scenario. This is just one of those situations. But I'd rather defend the religious discrimination lawsuit than the gender identity discrimination lawsuit. So, gender identity and disabilities. This is one of the areas that I think people tend to get tripped up on, and certainly something that's been very much in flux recently, whether people who are trans or non-binary are actually disabled. So we'll get into that because it is still something that exists in the form of gender dysphoria. So the American Psychiatric Association defines gender dysphoria as a conflict between a person's physical or assigned gender and the gender with which they identify. The Psychological Association says this may cause significant stress and or problems functioning. It's somewhat controversial to say that a non-binary or trans person is disabled or has a psychiatric illness. Many people in those categories do not believe they have a psychiatric illness or are disabled. If you think back until fairly recently, in the diagnostic manuals for psychologists and psychiatrists, people who were gay were considered to have a psychiatric illness until we collectively as a society came to understand that no, that's not correct. I wouldn't be surprised if we see a similar situation happening here, but it remains a diagnosable illness. It's still used in the legal statutes, even in New York, and it's certainly still something we're seeing in the case law, all of which I'm going to get into. That's just to say that I do think it's controversial, and it is somewhat controversial within that community of people as well. So, gender identity under the Americans with Disabilities Act. Non-disabling conditions concerning sexual orientation and identity are not protected under the ADA, which is our federal law that protects people with disabilities in the workplace. ADA regulations explicitly state that transvestitism, transsexualism, pedophilia, exhibitionism, voyeurism, gender identity disorders not resulting from physical impairments or other sexual behavior disorders are not protected. Note, that language is offensive. I gave you a heads up earlier when I told you that some of these things have fallen into disfavor. I think certainly transvestitism, transsexualism, those are not terms we use anymore. The ADA, this is 1991. This was not that long ago when these terms were considered appropriate to be used in federal legislation, right? So it shows you how far we've come since that time. And certainly, you should never be linking someone's sexual orientation or gender identity to pedophilia. We know that's completely incorrect, but if you go and look at the ADA, this is what it says. I'm as shocked as some of you look right now. I mean, that was just what it said, and that's obviously incredibly offensive. But that's the law, and that's what it says. So in 2017, a federal court in Pennsylvania, in a case called Blatt versus Cabela's, found that gender dysphoria could be a disability under the ADA because of the associated physical symptoms. So they didn't automatically throw that ADA claim out of court. They said, okay, you're a trans person, you have gender dysphoria, maybe that could be protected under the ADA, maybe it's associated with a debilitating life condition. We're going to let this case go through. We're not going to dismiss it out of hand. After that, there may be grounds to find that gender dysphoria should be reasonably accommodated. I don't know under the federal level if I can point to any other cases. I certainly can't point to any other statutes. I don't think I can point to any other cases that have held that definitively. Again, even in the Blatt versus Cabela's case, it wasn't held definitively that it was protected by the ADA, such that it would need to be reasonably accommodated, but we'll see what the federal law does in that area. I have to think that when the Supreme Court case comes down on Title VII, that will prompt the federal courts, depending on which way it goes, to start making rulings in the ADA context as well. So again, this is kind of the topic of the next year. This is our 2020 employment discrimination topic, I think, just because whenever the Supreme Court decides to rule on something, as it's done here, or will be doing here, it's something that we see trickle down to the states and to the lower courts and starts to affect many different areas. So we are all in New York, so we don't just get to talk about the ADA, we have to talk again about the New York State and New York City human rights laws. So the human rights law lists gender identity or expression as a protected category, which we know, that was gender, that was added back in January of this year, but it also views gender dysphoria as a disability. So, employers must engage in the interactive process and reasonably accommodate all individuals with a medical diagnosis of gender dysphoria. This is a case, and the only case, where you could ask for medical documentation. So if someone says, I'm transgender and I have gender dysphoria and I need 3 weeks of leave to deal with my illness, you could say, okay, just like any other illness, I need medical documentation of that. Are we going to put you on FMLA? How are we going to designate this leave time? But that would be the only case where you could ask for medical documentation related to transgender or gender identity status. So to summarize, you must not discriminate on the basis of transgender or gender identity status, and employers must reasonably accommodate employees who have a diagnosis of gender dysphoria. So if an employee discloses that they are transgender and asks for leave time, if it's not normally leave time you would give to another employee and they're claiming it's for medical reasons, you can ask for medical documentation, right? So if someone says, I'm trans and I'm going to take a vacation next week, you don't say, oh, I need your medical documentation. I need to prove that you're gender dysphoria. No. You say, enjoy your PTO, have a good time. If someone who's transgender says, oh, hey, I'm going to need the next 6 weeks off because I'm dealing with psychological counseling and I'm doing hormone replacement therapy and I need time off, you can say, okay, now I need medical documentation that you have a diagnosable illness that we can designate and put you on protected leave. So that's how that situation would work. FMLA leave is something I think comes into play here. So to qualify for the federal family and medical leave, you have to, as a transgender employee, you must have a serious medical condition related to the transgender status. These can include surgery, continued counseling, or hormone therapy. You can see FMLA guidance has been released on this and says that those things would qualify as a serious medical condition when it meets the other parameters of what would normally be a serious medical condition under FMLA, including hospitalization or repeated doctor's visits, things like that. FMLA leave may also be available for treatments for gender dysphoria. Obviously, when we're talking about putting someone on FMLA designated leave, individual circumstances are going to dictate what that particular person needs, what their medical documentation says they're entitled to. Our disability illustration. Jamie, an employee at XYZ company, comes to Human Resources and says they're non-binary and that their correct pronouns are they, them, and theirs. In this meeting, Jamie also alludes to needing time off, but doesn't specify as to why. So what are the company's obligations? I think most companies, when an employee says, I need time off, they go, when and why, right? I think you could ask that of Jamie if you would ask that of any other employee, right? Treat Jamie the way you would treat any other employee. Treat similarly situated people similarly. So I think that's important to remember. So if Jamie says, like I just said, if Jamie says, I need 6 weeks off to deal with surgery and hormone replacement, say, okay, I need some medical documentation. If Jamie says, I'm taking the week off to go on vacation, fine. But let Jamie kind of guide the conversation there. This is our bonus. Jacob, an employee at XYZ company, comes to HR and says his daughter is transgender and he needs time off to care for her after she has surgery. What are XYZ's obligations? I see one of you smiling at me. Everyone should know this. This is paid family leave, right? If your daughter needs surgery, you need to get paid family leave to care for her because she has a serious medical condition. Surgery would automatically qualify as a serious medical condition. I'm going to pretend that everybody in the room already knew that because it would just break my heart if you didn't know about PFL and that this could qualify. Yes?
Does it matter what other images?
For a child? Oh.
No, it says you just say daughter. So, I mean, if it's an adult child, does that make any difference?
So the question is, if it's an adult child, does it make any difference for PFL purposes? No, it does not. So non-discrimination policy. This is something employers have been considering adopting, especially when it comes to transgender and gender identity issues and becoming more prevalent in the workplace. There is a sample policy included in your materials or sample guidelines on drafting a policy that I was able to find. So places are considering adopting a gender identity or non-discrimination policy for everyone in the workplace. When I've settled these cases before the Division of Human Rights, they have insisted that one of these policies gets adopted. So I've had some practice drafting them myself. Different elements that you can include are things such as pronoun usage, what the company's policy is going to be on pronoun usage, what the company's policy is going to be on name changes, including name changes on employers' documents. And here I'm going to pause and just talk about that for a minute, because that's a question I get a lot. What are we supposed to do about name changes on an employer's documents? So if it's internal documents that the employer controls, things like a signature block or a sign-in sheet or something like that, you need to allow people to use the name that they identify themselves as. If it's something the employer can't control, such as a federal reporting form document or a state reporting form document, the appropriate thing to do is simply ask the trans or non-binary person, how do you want us to handle this? We have to file this form with the federal government. They're forcing us to select a gender for you. How do you want to handle that? And then documenting that employee's response. Because right now, the federal forms just have not, particularly the federal forms, although some of the state forms as well, still require people to identify themselves by gender, and particularly for non-binary people or for trans people in the process of transitioning, that's not always an easy thing to do. So it's just important to communicate with the person and ask them what they would like you to do in that situation. Yes?
I have a question here, and I'm assuming that if you have a longer-term employee that goes through a search process, you don't have to go back and change the documents, prior documents in the file.
So the question was, if you have a longer-term employee who I'm assuming went through the transitioning process, you don't have to go back and change their prior documents. No, I don't think so, because again, remember, we're operating under harassment and discrimination laws here, and the standard under federal law is still severe and pervasive, so you have to look at the conduct through that lens. Would it be severe and pervasive if you didn't go back and change all their prior documents? I doubt it. Would it be a petty slight or a minor inconvenience? Again, that's an open question. I don't think so, but I obviously can't stand up here and tell you one way or the other because we simply don't have enough practice either with transgender cases or with that new standard as of yet. So no, standing here today as Teresa, the employment lawyer, no, I don't think you'd be required to go back and change their past documents, but again, I can't tell you for sure. Other things to consider putting in the policy: restrooms, what you're going to do about access to restrooms for trans and non-binary people and for everyone in your workplace. Confidentiality, how you're going to communicate whether or not someone is trans to your other employees or to your supervisors. For supervisors, I recommend if one supervisor knows the correct pronouns, all supervisors should know the correct pronouns. I had a case once where a higher level supervisor knew the correct pronouns, but hadn't necessarily told the day-to-day supervisors what the correct pronouns were, and the employee brought a discrimination case based on that because, as we know, when one supervisor acts inappropriately, especially under our new standard for harassment and discrimination, that action or lack thereof is deemed imputed to the entire legal business entity. So that's just something I would communicate with your supervisors. In terms of communicating it to other employees, non-supervisory employees, that's something I certainly think you could do, but on that one you might want to check in with the trans or non-binary employee and say, how do you want us to communicate this to your coworkers? Do you want us to communicate this to your coworkers, or do you want to handle that? and see what the response is. Obviously, you'll want to have a policy on reporting harassment and discrimination for transgender and non-binary types harassment, and then have an acknowledgement if separate from your handbook. That's just good practice for all policies. So, as our takeaways, please be mindful of correct names, pronouns, and other terminology. Please be aware of the impact of the New York State Human Rights Law, FMLA, ADA, and other statutes when assigning leave requests or assessing leave requests. And then consider adopting a gender identity non-discrimination policy.